So just 1 second so the live stream catches up. It's now in session.
Good morning, everyone. My name is Evelyne Asaala. I'm the presiding judge. With me are my two other colleagues whom I would like to invite so that they introduce themselves. Welcome.
Good morning, everyone. So my name is Kazushige Doi. I also joined your session today.
And good morning, everyone. From me, my name is Matthew Cross.
Thank you very much. I now will welcome the prosecution to introduce themselves.
May it please the Honorable Court. Greetings, Ms. President and Your Honor. I am Vipassana Hussain, representing the Office of the Prosecutor in the case concerning the defendant, Mr. Gravos. It shall be my endeavor to establish two things in the next 15 minutes. That is, one, the case against Mr. Gravos is admissible. Two, the court has jurisdiction to try this case. This shall be followed by my co-counsel, Ms. taking 10 minutes to establish that Mr. Gravos should be held criminally responsible for genocide. We'll reserve 5 minutes for rebuttal.
Thank you very much, prosecution. I now invite the defense team to introduce itself.
Good morning, Madam President, Your Honors. My name is Dylan Jesse Andrian, and along with my co-counsel, Ms. Nicole Binder, we plead on behalf of the defense. I will speak for 15 minutes and Ms. Binder for 10.
Thank you very much, defense. We now move to oral submissions and we begin with the prosecution.
Mr. President and Your Honor, in the catastrophic aimed at destroying Castilians, around 286 lost their lives and several others lost their dignity at various incidences spanning across months. As the prosecutor, it is my duty to assist this court in putting an end to impunity for the defendant who is responsible for genocide by ensuring his effective prosecution. Your Honor, on this note, I shall begin with the first issue. That is, the present matter is indeed admissible under Article 17 of the Rome Statute. The negative structure of Article 17 implies that a case is generally admissible unless the prerequisites of inadmissibility are fulfilled. I shall prove that the present case passes the considerations of complementarity and gravity to my two submissions. That is, one, Hanatun is unwilling and unable to
Maybe we allow her a few more minutes. She seems to be having some technical problems.
Should I just stop the clock?
Yes, please.
Okay.
I don't know how long we can allow her.
You can grant an extension of 5 minutes
5 minutes
at maximum.
Okay. So if she's not back within 5 minutes, then the colleague can pick it up, right? Morali? Maybe. Okay.
Am I audible, Ms. President?
No, we can't hear you. It's only when you said Am I audible? But otherwise, we've been able to hear you.
Am I audible now?
Okay, try speaking. We can hear you. No. Unfortunately, we can't hear you. So we are giving you 4 more minutes just to try and sort it out. If not, then your colleague Murali or Pikri Kaushik can pick it up from there.
Am I audible? Your Honor, can I continue? Your Honor, am I audible now properly? I try to fix my internet.
We can hear you now. Can you try speaking?
Yeah, so I shall begin with my first issue. That is, the present matter is indeed admissible under Article 17 of the Rome Statute. Am I audible?
Yeah. Can we confirm that we can hear her now?
All right.
Yeah, right? Okay. So we can continue from where you left. And timekeeper, just keep
All right.
counting.
I shall prove that the present case passes the considerations of complementarity and privacy to my two submissions. That is how
So we've lost you again. So you want to continue?
Your Honor, am I audible?
Council, this is Judge Cross. We've also temporarily lost the presiding judge, so we'll take a couple of seconds while she returns. I'm afraid we can't hear you at the moment, Council, either. I see a notification that you're speaking, but I can't understand what you're saying.
Your Honor, I'm speaking now. Am I audible now? I have changed the settings pretty much. So let me know if I'm properly audible at this point.
I'm afraid, Council, you're not really audible. If you speak very slowly, we can probably follow you, but you would have to speak very, very slowly.
Your Honor, could I keep my video off? Maybe that could help the connectivity to an extent.
You can switch your video off.
All right.
Okay.
So I will continue from here, Your Honor. Okay. So beginning with the first ground of unwillingness, Your Honor, the PCC's proceedings are in consonance with the complementarity principle. The burden is on the defense to prove that concrete, tangible, and progressive investigative steps were taken to establish inadmissibility pursuant to pre-trial Chamber 1's decision in the admissibility of the case against Abdullah El-Sunisi in paragraph 298. While the defense may contend that domestic investigation was initiated, My first argument is that Hanatun was unwilling and unable to carry out a genuine investigation because, one, the investigative steps are not concrete and progressive, and two, they meet the thresholds of unwillingness under Article 17(2). Your Honor, the defense has not adduced evidence to prove concrete and progressive steps, which include state action in documenting witness testimonies like that of Mr. X, creating a witness protection program, conducting site visits and interviews in Luz, Luzari, and Civil, and collecting evidence. Even at the fag end of the military court proceedings, which is to be concluded in August 2022 itself. A mere initiation of investigation and arresting the accused are not sufficient steps as per ICC Pre-Trial Chamber 1 in paragraph 47 and 70 of Prosecutor versus Simon Bagbo decision on the Cote d'Ivoire challenge to the admissibility of the case against Simon Bagbo. Thus, Your Honor, the defense cannot rely on the information on the mere establishment of military court and arrest of the defendant in paragraph 17 and 18. Your Honor, the ICC Appeals Chamber and Prosecutor versus Saif al-Islam Gaddafi judgment on the appeal of Mr. Abdullah al-Sanusi in paragraph 218 held shielding the absence of an intent to bring the defendant to justice and lack of independence and impartiality as determinants of unwillingness to genuinely prosecute. The prosecution submits that the military court's investigations were a show trial instituted not with the intent to bring the defendant to justice, but rather to avoid ICC's fair trials in the matter. Therefore, they satisfy the three limbs of unwillingness provided under Article 17(2), that is, 1, political objectives and unjustified delay, 2, shielding through formulation of an extrajudicial body, and 3, systematic lack of independent and impartial investigation. Your Honor, political objectives and unjustified delay are evident in paragraph 6 and 18 of the case fact, which proves that Hanatun unwillingly instituted investigation after compelling diplomatic and political pressure by the European Union, ICC state parties, and from national and international human rights organizations. Further, Your Honor, the timeline of the case demonstrates how, first, the military court was established on 10th December 2021, which was only after the pre-trial chamber issued a warrant of arrest on 15 September 2021. And Your Honor, this occurred 3 years after the UNSC resolution of 2022, thereby proving unjustified delay. Your Honor, turning to the second limb of shielding, the military court was an eyewash to shield the defendant. According to paragraph 6 of case fact, it is clear that there were 3 branches of the state. Even then, a military court was set up to conduct investigation, despite the nation having a functioning judiciary. Such a step, Your Honor, raises the concerns of dual office holding and the executive nature of the body, on which the defense has not adduced any clarification. Thirdly, Your Honor, there is sufficient evidence to prove impartiality, lack of impartiality and independence because, first, both the party responsible for setting up the military court and the party being investigated have either held or are holding influential positions in the military. Second, public statements to the detriment or in favor of the suspect, breach of the presumption of innocence, discriminatory stance of officials or the executive, etc., could very well be indicators of impartiality in the proceedings pursuant to OTP's policy paper on preliminary examination. Your Honor, according to paragraph 18 of the case fact, high-ranking military officials advocated for the defendant's release even before the investigation was completed. That speaks volumes about the impartiality and independence of the investigation, Your Honor. Third, as an
Let me ask a question. The high-ranking officers that you are citing have not been involved in the investigations of Mr. Greva. So why would you use them as an excuse that there is impartiality?
Your Honor, as the prosecution submitted, public statements to the detriment or in favor of the suspect, breach of the presumption of innocence, discriminatory stance of officials or executive who can either be or not be involved in the proceedings are also indicators of impartiality because even though they were not directly involved, they were indirectly a part of the military personnel who were in turn investigating the defendant. So this was pointed out in OTP's policy paper on preliminary examination in point 54, Your Honor. Therefore, we submit that it does affect the impartiality aspect of the case.
Okay, proceed.
All right. Third, as an alternative perspective to the previous point, Your Honor, even if we deny the high-ranking official's bias towards the defendant, there could be a bias acting against the defendant because General Hitch is a political rival of the defendant, Your Honor. In all these cases, the ideals of impartiality and independence stand compromised. Thus, Your Honor, military court's constitution was evidently a rushed response to international pressure. It was neither impartial nor independent, but merely a shield to avoid ICC's fair proceedings in the matter. Hence, pursuant to Article 17.1 and 17.2, Hanatun is unwilling to prosecute the defendant. Your Honor, moving on to inability of Hanatun, PTC 1 in Prosecutor versus Saif al-Islam Gaddafi and Abdullah al-Sanusi, decision on the admissibility of the case against Abdullah al-Sanusi, in paragraph 210, accorded an enhanced burden of proof on the state challenging admissibility to show availability of an independent judicial system. The defendant has spoken about the political and economic collapse of Hanatun on record, Your Honor. In these circumstances, there is an even greater burden on the defense to prove that, one, they do not lack domestic legislation to prosecute the defendant on crimes of an international gravity as genocide. Two, they have the ability to collect and preserve evidence. Three, the defendant was provided legal assistance in the military court. And four, while the administrator changed in the military coup of General Hitch, the personnel did not. So the defense should show that the military court is maintaining impartiality during this transition as well. Your Honor, the defense's failure to prove any of these conditions would imply inability of the state of Hanatun to prosecute, rendering the case admissible pursuant to Article 17.3. Mr. President and Your Honor, this takes me to the second argument, that is the acts of genocide perpetrated by Mr. Gravus were of sufficient gravity. Gravity concerns Articles 6 to 8 Ratione Materiae jurisdiction and obliges the ICC to select among the most serious crimes. I will be proving the same in my factual submissions pertaining to a crime as severe as genocide in the second issue, Your Honor. With this, I conclude my first issue of admissibility and shall now delve into the second issue, which is that the court exercises Ratione Materiae jurisdiction over the case. Your Honor, the prosecution submits that the requisite Ratione Materiae jurisdiction is made out as the crime of genocide under Article 6A and 6C has been committed. I shall prove this in two counts. First, mens rea or specific intent to destroy Castilians is present. And second, actus reus in the direction of eradicating Castilians is also present. Your Honor, turning to the first requirement of specific intent or dolus specialis to destroy the group in whole or in part. Castilians are an ethnic group by the definition given by the Trial Chamber 2 in paragraph 98 of ICTR's Prosecutor versus Kaishima. The definition reads, a group which distinguishes itself or a group identified as such by others and the perpetrator. Your Honor, Castilians fulfill this parameter as the defendant identifies them as Castilians on multiple occasions. Your Honor, the indication of specific intent to destroy is rarely overt. Therefore, Trial Chamber 2 in ICTR in paragraph 93 of the same case envisioned a circumstantial evidence threshold like the physical targeting of the group or their property, the use of derogatory language, the methodical way of planning, and the systematic manner of killing, among others. The defendant has demonstrated specific intent to destroy the Castilians based on their ethnic identity, and I shall prove this in 4 points. First,
well, just before you go on, can I ask you a question, please?
Yes, Your Honor.
Is it your case that the defendant is the only person with the specific intent for genocide? Or do you contend also that other people also have the specific intent for genocide?
Your Honor, proving the specific intent of genocide to be present with Mr. Gravus would be sufficient to prove that his subordinates were acting within his orders and were also actively involved in the genocide. So my case is to prove that Mr. Gravos himself had the specific intent to destroy, and thereby he produced various orders through which his subordinates also perpetrated the same.
So if I was to push you, counsel, at the end of the day, would you say that the subordinates share the specific intent for genocide? Or are you saying that they do not share the specific intent for genocide, but they're merely following Mr. Gravos's orders and he has the intent?
Your Honor, Mr. Gravos has the intent and they were merely following his orders. So however, even though they did not specifically intend to destroy Castilians, by following the orders of Mr. Gravos, they would also be held liable under this case.
Thank you, counsel.
The defendant has demonstrated the specific intent, and I shall prove this in 4 points, Your Honors. First, the defendant, wearing his military uniform, used derogatory language on air. He referred to the Castilians as lying rats and vowed to eradicate the Castilian cancer from the map of the country. This was preceded by a systematic ostracization of Castilians by reducing federal funds for payments and political representation within 1 month of coming to power to propagate his own pan-Hano nationalist ideas, Your Honor. Second, the orders of the counter-terrorism campaign meet the systematic state policy threshold, Your Honor. Paragraph 11 of the case facts demonstrates how the campaign bestowed unfettered powers to the SPG and NDF. It deployed highly aggressive language, such as wanting to destroy CNF terrorists and their Castilian supporters and eliminate destructive social factions. This proves that the defendant did not merely want to find a temporary solution to Castilians, but wanted to permanently eradicate them from society, Your Honor. Third, according to paragraph 13 of the case fact, a local of Castilla who the state deemed as a Castilian was forced to say he was a CNF supporter. However, he was released only upon discovering his Hano ethnicity. Your Honor, the same paragraph mentions Mr. Bryan openly stating that the forces were acting under the orders of Mr. Gravos, and no correction or clarification to this statement followed, which confirms its veracity. Fourth, the attacks targeted the most densely populated cities, Luz and Luzari, with an intent to destroy a substantial proportion of Castilians, which satisfies the in whole or in part threshold of genocide, Your Honor. With this, I have established the defendant's dolor specialist through systematic discriminatory conduct targeting the very same group of Castilians. Thus, Your Honor, the requirement of mens rea is satisfied. Your Honor, my second count is that the requirement of actus reus is met. The prosecution submits that genocidal killing under Article 6A means causing the death of another person, and causing the death of one member also suffices. This was held in ICTR appeal chamber in paragraph 9 of prosecutor versus Silvestre Gacambitri. Your Honor, according to paragraph 12 of the present case, 200 Castilians were shot dead. Out of this, only 2 were CNF members in whose garb the government was actually running the campaign. Your Honor, moving on to the genocidal conditions of life under Article 6C, the ICTR trial chamber in paragraph 505 of prosecutor versus Akaisu held that infliction of conditions of life should be construed as the methods of destruction by which the perpetrator does not immediately kill the members of the group, but which ultimately seek their physical destruction. Your Honor, these conditions include subjecting the group to a subsistence diet and generally creating circumstances that would lead to a slow death, such as lack of proper food, water, shelter, clothing, sanitation. In the present case, all the thresholds are met as the defendant subjected Castilians to subsistence diet by blocking all routes of trade and food supply, which caused a very massive famine, Your Honor. This filled the streets with bodies of dead women and children. Your Honor, the defense may argue that this conduct was a preventive security measure. However, they have not adduced any evidence to show any measure to protect the so-called civilians of that region either. Resources were indiscriminately blocked without any justification or backup supply, leading to subsistence diet, and in the absence of medical supplies, and all this amounts to conditions of slow death for ultimate destruction of Castilians. Your Honor, all of these acts were committed intentionally to cause substantial harm to the Castilian population, and thus certainly fulfill the requirement of actus reus. With that, Your Honor, I conclude my second issue. I would now invite my co-counsel to take over and address the third issue.
Hi, am I audible?
Yes, we can hear you.
Your Honors, as my co-counsel previously established, genocide has been committed, and the individual that should be held responsible is Mr. Gravis. Thus, I, Maitri Murli, shall now take 10 minutes to establish that Mr. Gravis is criminally responsible for genocide under Article 28A of the statute. I will be addressing this issue in 4 parts. First, there existed a superior-subordinate relationship between Mr. Gravis and his security forces. Second, Mr. Gravis had superior authority and control over the forces that committed the crimes. Third, Mr. Gravis had knowledge or could have had knowledge that the forces were committing or were about to commit these crimes. And fourth, the crimes committed had resulted from Mr. Gravis's failure to exercise control and take reasonable measures. Coming to my first submission, Your Honors, there definitely existed a superior subordinate relationship between Mr. Gravis and his security forces. The ICTR trial chamber in the prosecutor versus Lawrence Samanza in paragraph 401 held that a superior subordinate relationship requires a formal hierarchical relationship where a superior is senior to a subordinate. The pretrial chambers in the Jean-Pierre Bemba Gombo confirmation of charges decision in paragraphs 408 to 410 held that the prosecution must prove that the accused was either a military commander, a de jure commander, or a person effectively acting as such, a de facto commander. Your Honors, from paragraphs 6 and 7 of the case facts, we can see that Mr. Gravis had declared himself president of the country, and he was the de jure president and commander-in-chief of the armed forces. Your Honors, this is proof enough that there existed a superior subordinate relationship with Mr. Gravis at the top of the chain of command. My second submission, Your Honors, is that Mr. Gravis had superior authority and control over the forces that committed the crimes. Your Honors, the pretrial chambers in the Jean-Pierre Bemba confirmation of charges decision in paragraph 414 held that effective control is a manifestation of a superior subordinate relationship between the suspect and the subordinates. The ICTY appeals chamber in paragraph 197 of the Celebici appeal judgment held that a court may presume that the possession of de jure power prima facie results in effective control unless contrary proof is produced. Your Honors, the ICTY trial chamber in the prosecutor versus Radovan Karadzik at paragraph 580 to 583 held that effective authority and control is the material ability to prevent or punish the commission of crimes or to submit the matter to competent authorities for investigation and prosecution. Your Honors, the power to issue orders is indicative of the existence of effective control. Thus, Your Honors, there are 2 requirements to be fulfilled under the submission. First, the existence of a superior subordinate relationship, which I proved in my previous submission. And second, the existence of effective control by the superior. For the second requirement, Your Honors, I would like to draw your attention to paragraph 11 of the case facts, where Mr. Gravis's counterterrorism campaign is introduced. In clause B, Mr. Gravis has stated that the NDS and the SPG will operate under the direct command of Mr. Gravis and shall have the duty to eliminate destructive social factions. The fact that Mr. Gravis had effective control over the actions of the security forces was only affirmed by Mr. Bryan, the head of the police department, in paragraph 12, where he admits that the NDS and the SPG were only following Mr. Gravis's orders while murdering custodians. Thus, Your Honors, both the requirements under the submission are fulfilled. My third submission, Your Honors, is that Mr. Gravis had knowledge or could have had knowledge that the forces were committing or were about to commit these crimes. Your Honors, the ICTY trial chamber in Cordic and Serkis in paragraph 428 held that the actual knowledge of a military commander will be proved easily, considering the fact that he will be part of an organized structure with established reporting and monitoring systems. The ICTY trial chamber in the Karadzik case in the public redacted version of the judgment in paragraph 584 to 586 stated that is showing that a superior had general information in his possession, which would put him on notice of possible unlawful acts being committed by his subordinates, is sufficient to prove that he had reason to know. The information does not need to provide specific details about the unlawful acts committed. Your Honors, in our present case, there is ample evidence to prove knowledge. I would like to bring your attention to Clause E in paragraph 11 of the case facts, which state that the heads of all 3 security divisions will report to Mr. Gravis. Mr. Gravis was also seen communicating with Mr. Bryan and Ms. Jolie regarding the situation in Casteria. Moreover, from paragraph 11 and 12, we can see that he allowed his soldiers to murder Casterians. When the entire international community was aware of the atrocities being committed in the region of Casteria, we can be certain that Mr. Gravis definitely had an idea. His soldiers were also seen chanting Casterians are cancer. This, Your Honor, proves that Mr. Gravis certainly had the knowledge of the crimes that his forces were committing. My fourth and final submission, Your Honors, is that the crimes committed had resulted from Mr. Gravis's failure to exercise control and take reasonable measures. Your Honors, the ICTY trial chamber in the Karadzik case in paragraphs 587 to 590 held that reasonable measures are those that are reasonably falling within the material powers of the superior. Reasonable measures can include reporting the matter to competent authorities, carrying out an effective investigation to establish the facts, issuing specific orders prohibiting or stopping the criminal activities, and taking disciplinary measures against the commission of crimes. Your Honors, I have proved previously how Mr. Gravis had knowledge of the crimes that his forces were committing. He, however, failed to do anything about this and actually, in fact, actively asked his forces to murder Casterians. The ICTR in Prosecutor versus Karamera and Girimpadse in paragraphs 1564 to 1565 considered that the only reasonable measure for preventing mass killings by the Kigali Interhamwe would have been to take any step that delivered the message that they must immediately stop murdering the Tutsi civilians. However, Girimpadse used extremely vague language that ignored the genocide that was being perpetrated by his subordinates. Here, the court did not accept that Girimpadse took reasonable measures to stop the crimes by his subordinates. Your Honor, we can see that in our case, Mr. Gravis did not even take a single measure against his forces, let alone a reasonable one. We can conclude that Mr. Gravis did not exercise proper control or take reasonable measures. I would like to rest my case, Your Honors. I express fervent hope that justice be rendered to the victims of this crime that has greatly shocked the Republic of Hanaton. Wherefore, in light of the issues raised, arguments advanced, and authorities cited, the prosecution most respectfully requests the chamber to declare that 1. The case against Mr. Gravis is admissible pursuant to Article 17. 2, the case falls within the jurisdiction of the court pursuant to Article 19. And 3, that there exists reasonable ground to hold Mr. Gravis criminally responsible under Article 28. Thank you.
Thank you very much, prosecution. I now invite the defense team to make their oral presentations.
Good morning again, Madam President, Your Honors, may it please the court. Your Honors, the Office of the Prosecutor has asked this court to do 3 things. First, to find the case admissible, and in doing so, deprive the state of Hanaton of its right and its responsibility to carry out domestic proceedings. Second, to find that the court has jurisdiction over 2 counts of genocide built upon dubious inference drawn from questionable evidence. And third, to find Mr. Gravis responsible for conduct committed beyond his control and knowledge. Now, in our submissions, we shall demonstrate that these assertions are inaccurate, unfounded, and ultimately unreasonable. Turning to our first argument, we submit that this case is inadmissible pursuant to Article 17 of the Rome Statute. According to Article 17(1)(a) of the Rome Statute, a case is inadmissible if it is being investigated by a state that has jurisdiction over it, unless that state is unwilling or unable genuinely to carry out those proceedings. Now, the prosecution has alleged that the defense has the burden of proof to show that there are investigations, and furthermore, the state is not unwilling or unable genuinely to carry out proceedings. However, this is inconsistent with the general principle of law that the actor bringing the claim should substantiate their allegations. And also, this would not be consistent with the 2013 Al-Sanusi decision on admissibility, paragraph 208, in which any factual allegation raised by any party or participant must be sufficiently substantiated in order to be considered properly raised. Our allegations in this case are that there are investigations ongoing, and that is the end of our burden of proof. The burden of proof then shifts to the prosecution to show that there was an unwillingness or an inability on the part of the state to carry out those proceedings. Now, in the first place, we will show that there were investigations, and this is clear from fact 18. There was a military court set up and investigations are ongoing. Now, the prosecution has suggested that this isn't sufficiently concrete. There is reference made to Gaddafi in which more steps are required by the prosecution. For example, witness testimony, collecting of documentary evidence, and providing for witness protection. However, Your Honors, if we look at the Gaddafi decision, in particular paragraph 55, we'll find that those are only factors that exemplify an investigation. Those are not the only ways to show that there are indeed investigations. So since we have a military court, and since we know that the investigations have begun and they will conclude in August 2022, it is clear that the first limb of the complementarity test is fulfilled, that there are investigations, and that the court should find that this case is inadmissible. Now, this case could be admissible. Yes, Madam President.
Yes, the prosecution alleges that there are no genuine investigations. And part of the reasons is that, we have had senior officials asking for release of Mr. Grevas. What would be your response?
Well, Madam President, we do take note of that. This is a claim that there is an unwillingness on the part of the state of Hanatun due to a lack of independence and impartiality pursuant to Article 17.2c of the Rome Statute. We would disagree with the prosecution's formulation, and we cite before the court the Al-Sanusi decision, paragraph 241, in which statements infringing the presumption of innocence of the accused only affect independence or impartiality if they emanate from the judicial authorities involved. Now, we know from fact 18 that yes, these were statements made by high-ranking military officers. However, clarifications 3 makes it very clear that these persons have no connection to the military court. Not that they have tenuous connection, not that they have weak connection, they have no connection. And so because they have no connection, their statements would have no bearing on the independence and impartiality of these domestic proceedings. Now, aside from claims that there are unwillingness due to a lack of independence and impartiality, the prosecution has also alleged that there has been an unjustified delay, which is grounds for unwillingness under Article 17.2b of the Rome Statute, as well as there are claims that Hanatun is shielding Mr. Gravis from prosecution, and this would be grounds for unwillingness under Article 17.2a of the Rome Statute. For both of these claims, there is no evidence provided by the prosecution. And we know from the Gaddafi decision, paragraph 54, that there must be evidence of a sufficient degree of specificity and probative value. It is not sufficient for prosecution to rely on inference, however reasonable that may be, unless that inference is drawn from evidence. Therefore, it is clear that because there are investigations, because there are proceedings at the national level, the court should allow the state of Hanatun to deal with this matter and find that this case is inadmissible. Now, having addressed issues of admissibility, I'll now turn to whether this court has jurisdiction in this case. Now, we contest the material jurisdiction of this court over the 2 counts of genocide submitted by the prosecution, namely genocide by killing under Article 6a of the Rome Statute, and genocide by deliberately inflicting certain conditions of life calculated to bring about the physical destruction of a protected group in part or in whole, pursuant to Article 6c of the Rome Statute. Now, before I proceed, I'd like to address a concern raised by Judge Cross. For a crime to occur within the jurisdiction of the court, a perpetrator must have committed the actus reus, the material conduct, with mens rea. This means it is the perpetrators that must have the mens rea and not Mr. Gravis. This is a very basic principle of criminal law that, of course, is reflected in Article 30, subparagraph 1 of the Rome Statute, as well as the elements of crimes. Now, what the prosecution has done is referred to the material conduct of the NDS, SPG, and police, but referred to the mental element of Mr. Gravis. Your Honors, this, unless there is this coinciding of actus reus and mens rea, there is no crime, and without a crime, the court would not have jurisdiction. However, even if we were to take prosecution's arguments at their very strongest, and to assume that there would be genocidal intent on behalf of the NDS, SPG, and the police, we would submit that this would still not stand, that at best, the evidence only points to discriminatory intent. Now, before I address this argument, I'd like to explain the difference between discriminatory intent and genocidal intent. According to the Cooper-Skitch trial chamber judgment, paragraph 636, discriminatory intent can take multifarious inhumane forms and manifest itself in a plurality of actions, including murder. However, it is not genocide unless that intent is accompanied by the intention to destroy, in whole or in part, the group to which the victims belong. So in short, mere targeting of a person because of their membership to a group does not prove genocidal intent. It is only until it is clear that the motivation behind these actions are one to destroy the group, either in part or in whole, that we can call this genocidal intent. Now, Your Honors, we would submit that our case only demonstrates discriminatory intent. We would refer the court to the Galich trial chamber judgment, paragraph 593. There, the court looked at a situation where there was constant sniping and shelling of a civilian population. Indeed, on a single day in 1993, 400 artillery and mortar impacts were recorded. There were also constant attacks between September and December 1992. And yet the court held that these attacks were not so numerous and not so consistent or intense to show genocidal intent. They did not, in the words of the Galich trial chamber judgment, did not intend to wipe out the population. Now, in stark contrast, Your Honors, or very similarly, we'd find that we have one incident taking place on a single night that took place in 2 cities, and this affected 200 people. Now, that's not to discount the tragedy suffered by these persons, but we have to ask ourselves whether this meets that very strict, that very stringent threshold of genocidal intent. Were they targeting these persons because of their membership to the group, or was there that added element of intention to destroy that group in part or in whole? The defense is firmly of the view, and we think this is consistent with the jurisprudence of the ad hoc tribunals, that this would not be genocidal intent and at strongest discriminatory intent. Now, turning to the second crime submitted by the prosecution, the crime under Article 6C of the Rome Statute, we submit that the intent behind the blockade was not one of genocidal intent. Now, we refer the court to the 2007 Bosnian genocide case, paragraph 189, in which that court held, specific intent is also to be distinguished from other reasons or motives the perpetrator may have. Great care must be taken in finding in the facts a sufficiently clear manifestation of that intent. Now, we know from facts 15 and 16, the reason why a blockade was set up was to prevent a danger of CNF attacks. Furthermore, the reason why the state of Hanatun was not able to ameliorate the situation was because there was severe economic deterioration. It is clear then that the motivation, the intent behind this blockade was not one of genocide. Was it one of violent overzeal in dealing with a perceived security threat? Certainly. But whether this was genocide is a different question altogether. And we submit that it is very clear from the facts that the intent is to deal with a security threat and not one of a genocide. We further note that in the ICTR Kayishema and Ruzindana case, paragraph 288, the erection of roadblocks is a natural phenomenon during times of war. And this is precisely what we have here. We have a conflict, and the state is trying to deal with it. They are going beyond what is permitted, but they are not necessarily committing genocide. And that's the central point in this case. Now, I would like to turn briefly back to count 1, because we note that the prosecution has relied on an item of evidence from fact 13. This is Mr. X's testimony as recorded by IHRD. And this obviously plays an integral part in prosecution's submissions, as this would show that there was discriminatory intent, perhaps to the extent of genocidal intent. Of course, this isn't a concession that we're making, but this would be prosecution's arguments at their strongest. Now, we submit that this item of evidence should be declared inadmissible pursuant to Article 69, subparagraph 4 of the Rome Statute. Now, according to this court's jurisprudence, particularly in the Katanga and Chui decision on the prosecutor's bar table motions, paragraph 14, the court first considers the probative value of evidence and then weighs it against the potential prejudicial effect. Now, when we look at the probative value of this item of evidence, we submit that it has no probative value. If we look at the 2019 Gbagbo majority opinion, paragraph 43, it says clearly that anonymous hearsay has no probative value. That's precisely what this is, anonymous hearsay. Now, when we compare it to the prejudice caused to a fair trial, we see that this does cause prejudice to the defense. According to the Katanga and Chui decision that we cited earlier, paragraph 42, the accused has a right to examine or have examined adverse witnesses, and this is of fundamental importance to the fairness of the proceedings. No judgment can be rendered safely if it is based on evidence prepared on behalf of one party, which the opponent has not been able to test or verify. And so very clearly, yes.
Sorry, if I may interrupt you a second. Does the defense have the same right to confront the witnesses who may testify against them at the confirmation stage of proceedings?
Yes, Your Honor. The defense does have the right to, at some point, have examined the witness. We know this, for example, from the Lubanga decision on the prosecution's application for the admission of the prior recorded statements of two witnesses, paragraph 19. The defense should have the right to examine at some point, whether it be at pretrial or even at trial.
But just to clarify, since we are pre-trial at this point, and this is a pre-trial motion, if you like, to kick the whole case out before it gets started, is now really the time when we should be looking at the sufficiency of the prosecution's evidence? Because of course, even at the confirmation stage, they're still entitled to bring additional evidence at trial.
Yes, Your Honor, yes, that's a fair concern. However, we submit that this court should consider this an exceptional situation because of the prejudice caused to the defense. This is the one item of evidence upon which prosecution's submissions rest, or the strongest piece of evidence. And this item of evidence is so clearly prejudicial to the defense. And furthermore, as we've stated earlier, it has no probative value. And so the defense is of the view, and we hope that the court would be of a similar view, that this item of evidence is so prejudicial that it warrants rendering it inadmissible even at this very early stage of the proceedings. Now, in light of our submissions, we would ask the court to find this case inadmissible and to find that it does not have jurisdiction over these two counts of genocide. This concludes the submissions of the first speaker for the defense. Thank you for your attention.
Good morning, Madam President, Your Honors, may it please the court. My name is Nicole Binder, and on behalf of the defense, I will be responding to the prosecution's claims regarding Mr. Gravis's criminal responsibility for genocide. My submissions are threefold. Firstly, that Mr. Gravis did not have effective control over the NDS, SPG, and police. Secondly, that Mr. Gravis did not have actual knowledge, nor should he have known of the NDS and SPG's criminal conduct. And thirdly, Mr. Gravis did not fail to fulfill his duties to repress or refer under Article 28A(2) of the Rome Statute. Turning, if I may, to my first submission, namely that Mr. Gravis did not have effective control over the NDS, SPG, or police. Now, the prosecution has claimed that Mr. Gravis's de jure position is sufficient to prove effective control in the absence of other evidence, and has further claimed that his power to issue orders is in and of itself sufficient to establish his effective control over his subordinates. However, according to Cordic and Turquet's judgment, paragraph 369, mere belonging to a chain of command is not per se sufficient to show effective control. So mere finding of Mr. Gravis's de jure position or his capacity to issue orders by virtue of a chain of command is insufficient to prove his effective control. And indeed, as was held by this court in paragraph 190 of the Bemba judgment pursuant to Article 74, two factors indicating a lack of effective control are: one, subordinate non-compliance with orders issued by the accused, and two, a weak or malfunctioning chain of command. Now, as regards the first factor, in case fact 11, Mr. Gravis explicitly limited the scope of the counterterrorism measures to, under subparagraph A, combat the CNF and its Castirian supporters that posed a threat to Hanatoon's public security, under subparagraph B, destructive social factions, and under subparagraph C, potential terrorist suspects. The language of the counterterrorism measures very clearly indicates that Mr. Gravis explicitly limited the scope of the counterterrorism measures to active security threats to Hanatoon. And furthermore, the context in which these orders were issued, namely the aftermath of a horrific terrorist attack in which 35 soldiers were immolated in their vehicles and 3 civilians were killed, as per case fact 10, further demonstrates the fact that Mr. Gravis explicitly limited the scope, again, to public security threats. Mr. Gravis further implicitly limited the scope of the counterterrorism measures to exclude civilians from their scope, as can be seen, or rather inferred, from Exhibit 1. However, none of his subordinates complied with these explicit and implicit orders. Assuming but not conceding the admissibility of Mr. X's witness testimony in Case Facts 13, the NDS and SPG engaged in numerous discriminatory acts targeting Castirian civilians, such as shooting 200 Castirian men dead for resisting arrest, kicking pregnant Castirian women in the stomach, and again, not obeying Mr. Gravis's explicit and implicit orders to target security threats and to not target civilians. The police similarly did not comply with Mr. Gravis's orders by, for example, initiating the blockade of Castiria in Case Facts 15, or by trafficking 86 female Castirian women into sexual slavery in Case Facts 14. None of these acts can possibly be deemed to be in response to legitimate security threats, and they're all targeted towards civilians. And therefore, Mr. Gravis was unable to ensure compliance with his orders by any of his subordinates. And as regards the second factor, namely a weak or malfunctioning chain of command, we can see that there was indeed a chain of command in this case, as defined in paragraph 419 of the Court of Chinchorka's judgment. There was a hierarchical structure with Mr. Gravis at the top, setting general policy objectives to then be carried down the chain for implementation. However, as I have demonstrated, these orders were very clearly not being implemented. These general policy objectives, as seen in, for example, Case Facts 11, were not being implemented, and therefore the chain of command was weak or malfunctioning. Yes, Madam President?
And so in the case facts, we see Mr. Gravis referring to the Castilian cancer, the need to deal with it. How do you relate to this statement?
Well, Madam President, it is true that in Case Facts 10, Mr. Gravis refers to the Castirians as a Castirian cancer and as lying rats. However, as was later clarified explicitly by his press secretary, these statements referred only to the CNF. And again, these statements were issued in the aftermath of a terrible terrorist attack by the CNF. So it is clear that Mr. Gravis did not himself hold any anti-Castirian sentiment and was merely referring to the CNF. Turning, if I may, to my second submission, having proven that Mr. Gravis had no effective control over any of his subordinates, my second submission concerns the fact that Mr. Gravis had no actual knowledge, nor should he have known, of the NDS and SPG's criminal conduct. Now, the prosecution has stated that Mr. Gravis's official position is sufficient to prove his actual knowledge. But pursuant to the Bagalishama judgment, paragraph 968, although an accused's official position may be a significant factor in determining actual knowledge, it is, of course, not a sufficient indicium. And therefore, I would like to refer to the Bemba judgment pursuant to Article 74, paragraph 193, in which several factors that are relevant in assessing actual knowledge, which cannot be presumed but may only be inferred on the basis of these factors, are indicated. And these factors include things like the number, type, scope, and time of the illegal acts, their widespread occurrence, and their notoriety. As regards the first factor, namely the number, type, scope, and time of the illegal acts, I refer to Case Facts 12. The illegal acts committed by the NDS and SPG were limited to 200 Castirian men. They were limited in scope to the killing of these 200 men who resisted arrest in only 2 cities in Castiria, Luz and Luzari. And furthermore, perhaps most tellingly, these illegal acts were limited to the night of 15th July 2019, and there is no indication whatsoever that these acts were repeated on any other occasion. And as was held in the Prilich judgment, paragraph 248, an important indicia of knowledge includes the fact that the crimes were committed repeatedly. And here, Your Honors, these crimes were clearly not were committed repeatedly, and therefore the factors of the number, type, scope, and time of the illegal act simply do not indicate that it is reasonable to conclude that Mr. Gravis had actual knowledge of the NDS and SPG's conduct. Turning to this,
if
yes.
I can just stop you there for a second. Are you saying that Mr. Gravis never came to know about these incidents? Because clearly there's a point when, as we know, it's these incidents specifically are condemned by the international community, which led to the UN Security Council resolution, which led to this court's jurisdiction. So I take your point about when he might have known, but perhaps you can comment on when you think this might have come into his knowledge.
Well, Your Honor, the international outcry in the UN Security Council resolution 2022 indicated in Case Facts 15, where brought to Mr. Gravis' attention on 15th October 2019, but both of these both of these informations only refer to the humanitarian crisis in Castiria, which was caused by the blockade of the police. And the international condemnation and the UN Security Council resolution of October 15, 2019, do not make any reference to the killing of the 200 Castirian men on 15th July 2019.
Well, it does say stop the extermination of Castirians. Surely that's enough to put him on notice that there might be a problem.
Perhaps to put him on notice, Your Honor, but that is not the standard that is applied by the ICC. In fact, that brings me to my other issue with the prosecution submissions, namely that they have referred to the had reason to know standard, which is applied by the ICTY, but is not applied by the ICC. The standard applied by the ICC is the should have known standard, as stated in Article 28A, and as further elaborated on in paragraph 432 of the Bemba confirmation of charges decision. So although perhaps there was information to put Mr. Gravis on guard that crimes were being committed by the police by virtue of the international condemnation and the UN Security Council's resolution, this standard is simply not applied by the ICC, and his duty was an active duty to acquire information of the conduct of his subordinates. But again, my submissions are not centered on Mr. Gravis's knowledge of the police's activities, but rather on his actual knowledge of the NDS and SPG's activities. And we submit that Mr. Gravis never acquired this actual knowledge, as the international outcry related only to the death of Castirians resulting from the famine that resulted from the blockade by the police. Returning briefly to the other factors that prove actual knowledge, I would like to refer to their widespread occurrence. Unlike in the Karamara et al. Judgment, paragraph 1530, where the crimes were, quote, so widespread and public that it would have been impossible for the accused to be unaware of them, end quote. Here, the killing of the 200 Castirian men was simply neither widespread nor public. Again, they were limited to one night, July 15, 2019, and were severely limited in number, type, and scope. Nor were they public, relating to the third factor, namely their notoriety. There is no evidence whatsoever that the acts were reported in media coverage of which Mr. Gravis would have been aware, and therefore they were neither public nor notorious to the extent that it would be reasonable to infer that Mr. Gravis had actual knowledge of these crimes. Turning briefly to my third and final submission, namely that Mr. Gravis did not fail to fulfill his duty to repress and refer under Article 28A. The duty to repress and refer merely requires a commander to take necessary and reasonable measures to repress the activity, the criminal conduct of his subordinates, where reasonable measures depends upon the degree of effective control the commander has at the time the duty arises, as was held by this court in paragraph 443 of the Bemba confirmation of charges decision, and further held in the appeal judgment of Bemba, paragraph 167, where the court stated that a commander simply cannot be expected to do the impossible. And here we submit that it was impossible for Mr. Gravis to take reasonable measures to discharge his duty to repress by virtue of the fact that he simply had no effective control at the time the duty to repress could have arisen as regards the police's conduct or the NDS and SPG's conduct. We have proven that he had no effective control over any of his subordinates. And this is further underscored by case facts 16 and 17, where respectively, he stated that his government was struggling to control the situation in Castiria, and in case fact 17, he was deposed and placed under house arrest following the military, political, social unrest in Hanatun and clashes with his deputy, General Hitch. It is therefore unreasonable to claim that Mr. Gravis had any effective control to discharge the duty to repress. And as regards the duty to refer, which comes into play when the commander has no power to take necessary or reasonable measures, I refer to the Bemba appeal judgment, paragraph 170, in which I quote, the chamber found that abstract findings about what a commander might theoretically have done are unhelpful and problematic, not least because they are very difficult to disprove. And the prosecution simply has not been able to prove that Mr. Gravis in concreto could have referred the issue to a competent authority. And this is merely an abstract and theoretical finding that that does not prove that Mr. Gravis has failed to fulfill his duty to refer. Thank you for your attention. This concludes the submissions of the defense.
Thank you very much, defense team. We now call upon the prosecution for rebuttals.
Am I audible?
Yes, you are.
May it please this court, Mr. President and your honors. The prosecution would like to present the following 3 points in the rebuttals. That firstly, our first rebuttal is a concern that is shared by the court as well. that, Your Honors, at this stage of the pre-trial chamber is not required to look into the evidentiary matters and in the probative value of the evidence submitted, as it was held in the case of Prosecutor versus Barushimana, decision on the confirmation of charges, para 44, that at the pre-trial chamber determination of evidentiary matters is inappropriate and should be done at the trial chamber stage in light of the whole of the evidence presented. Secondly, Your Honors, the defense is wrong in stating the threshold for inability. The prosecution agrees that not all evidence and investigative steps taken by the state need to be shown before the court. However, as it has been held in the jurisprudence of this court in the Al-Sanusi case, in the Saif al-Islam Gaddafi case, it is required from the defense that they show sufficient concrete and tangible steps. However, in the present case, the defense has only given two so-called steps, that is, first, the setting up of the military court, and second, the detention of Mr. Gravis, which the prosecution reiterates were held to be insufficient by the pre-trial chamber 1 in the challenge to the admissibility of the case against Simone Bagbo, para 65. Thirdly, Your Honors, the defense has conveniently ignored the many acts committed by the perpetrators in the present case. The defense has boiled down their arguments to only one night on 15th of July 2019. They have conveniently ignored that under para 14, the CNF, under para 14, families and unarmed civilians who were only trying to flee the bloodshed in the province of Castilla were shot dead without any provocation, thus nullifying the defense's claim that the target of the government and their policies was only the terrorist. Fourthly, Your Honors, the defense was, even if we take the defense's claim that Mr. Gravis had no knowledge or could not have known when the commissions of crimes were taking place, this is again a concern that was shared by this court, that under para 16, international community, the UNSC, as well as international reporters confronted Mr. Gravis. Further, a resolution by the UNSC was passed. Your Honors, this is sufficient to prove that there was subsequent knowledge on part of Mr. Gravis. And this subsequent knowledge should have triggered Mr. Gravis's superior responsibility to punish the forces and to submit the matters under Article 28A, which clearly were not taken by Mr. Gravis. Coming to the next point, Your Honors.
Counsel, if I can very quickly stop you there. If you're saying the knowledge is subsequent to the crimes, is that your position? Is that the earliest time you think Mr. Gravis had knowledge?
Your Honors, the prosecution would like to answer your question by clarifying our stance that even if we take the defense at their strongest, that Mr. Gravis did not have knowledge during the commissions of the crime or should not have had knowledge during the commission of the crimes, still, the subsequent responsibilities on Mr. Gravis were not fulfilled by him.
Thank you.
Further, Your Honors, the prosecution cannot reconcile the contradicting statements made by the defense. Your Honors, the defense relied upon para 11 points A, B, and C to show that the target were just the CNF terrorists and the supporters. However, what they also conveniently ignored was that in the same paragraph 11.C, it was Mr. Gravis who gave the security measures the free hand to take all measures that they considered necessary, thus showing that the Dole specialist was indeed shared by the perpetrators on ground as well. Lastly, Your Honors, it is undisputed that there were killings of Castilian men, women, and children. And often, the most heinous of crimes are often done under the facade of novel intentions, giving birth to impunity of grave crimes. And it is this impunity that the prosecution urges the court to put an end upon. If the counsel may be of no further assistance to the court, this concludes the prosecution's rebuttals.
Thank you very much, prosecution. I now call upon the defense team for their rebuttal.
Good afternoon again, Madam President, Your Honors. May it please the court. Here we make 4 points of rebuttal in response to the points made by the prosecution. Firstly, the prosecution has picked up on the court's concern that the pretrial chamber should not go into an assessment of the admissibility of evidence. And here they've cited the Mbarushimana confirmation of charges, paragraph 44. However, there is one line that is missing from their citation, and that is a wholesale, I'll go ahead and quote the paragraph directly. A wholesale assessment as to the admissibility of each item of evidence at this stage would unjustifiably delay the proceedings and give rise to an inappropriate predetermination of evidentiary matters. Your Honors, we're not asking the court to consider each and every item of evidence. We are asking the court to consider one item of evidence that is of such that is so egregious in its lack of probative value and that causes such prejudice to the defense that it would be incorrect to admit this evidence even at this early stage of the proceedings. And indeed, the court has done this in the past. For example, in Lubanga and in Gaisona, the court has found it pertinent to exclude items of evidence at pretrial. Therefore, we submit that this would not be contrary to the practice or the law of this court. Secondly, the prosecution has argued that there was an inability on the part of the state of Hanatun to carry out proceedings. However, we would like to address the fact that we did not make arguments on the inability of the state, but nevertheless, inability is evidenced by, and this is from the wording of 1723, or I apologize, 17.3 of the Rome Statute, an inability to obtain the accused or carry out proceedings in any other manner. Now, we know clearly that the state has the ability to obtain the accused. Mr. Ravis was placed under arrest and eventually transferred to this court in Fact 17. And indeed, in Fact 18, a military court was set up to institute proceedings against him. Therefore, it is very clear that this court, or rather that the Hanatun Domestic Military Court, is able to carry out domestic proceedings against Mr. Gravis. The prosecution has made a third point, which is that the Castilians were attacked without provocation. And according to the prosecution, this is sufficient to show genocidal intent. Now, Your Honors, even if that were the case, we submit this only shows discriminatory intent. This would show that these persons were targeted because of their membership to the group, but not necessarily that the perpetrators had intent to destroy that group. And that's what's sorely missing from our case, that crucial item of evidence. Finally, prosecution has also mentioned that Mr. Gravis did not share, or that he did share, the mens rea of his subordinates. And Your Honors, that very well may be the case. It could be that Mr. Gravis had genocidal intent. However, the mode of liability under which they charge Mr. Gravis is one of Article 28A, which is an omission form of liability. This means that the mens rea of the commander is irrelevant for determining whether a crime has indeed occurred. What matters is, did the perpetrators on the ground, the persons carrying out the material conduct, did they possess genocidal intent in carrying out that conduct? And as we may refer back to our previous submissions, they did not. Therefore, we submit that the court should find that it does not have jurisdiction in this case, that the case is inadmissible, and that Mr. Gravis is not responsible for any of the conduct alleged. And as a final point, the prosecution claims that it is very common that crimes are masked as other things. And we agree that that is something that we should be very wary of. However, in order for us to look beyond this mask, to claim that crimes have indeed occurred, we need evidence. This is one of the fundamental principles, even as far back as the Nuremberg Tribunal. This was established in Nuremberg Principle 5. So without evidence, Your Honors, we submit the court should not find that it has jurisdiction where it does not. Thank you for your attention. This concludes the submissions of the defense.
Thank you very much, defense team. The court will now adjourn and we will be back after a few minutes. Thank you very much. I think we will now adjourn for deliberations, then we will be back after a few minutes. So welcome back, and thank you very much to both teams. I must say this was a tough fight, and it is evident from the quality of the presentation from both teams. So I would like to open up by just congratulating the two teams. And before I call upon my colleagues to give their comments, make observations. And lastly, I will come in to announce the winning team and the best first speaker and second speaker as well. So I will call upon my colleagues just to make the observations.
Then maybe first, I give some feedbacks. I think both teams had presented very well. So your statements, arguments, generally so very close to each other. But first, yeah, for Defense Counsel, I think you had better to be so more careful about arguments arguments for criminalization in general, because I'm teaching so criminal law in general. That's why. If you argue so for criminalization, then you should argue really so each element. That means actually so special intention is maybe so symbolic elements and the most important elements of the genocide. But if you you should also clarify, so examine objective elements as well very carefully. That is my impression for you. And for the prosecution, I think so it was very good for me that you discussed not only so whether there was the duty of prevention by the side of the Mr. Graves, not only, but also you had also mentioned the possibility of the preventive measure. You have mentioned as well. That was for me very impressive. So so far, so from my side, thank you.
Thank you. I'd like to join my colleagues first of all by saying well done to all of you. Being an advocate is hard. I think being an advocate over the internet, whether you have technical problems or whether you do not have technical problems, either way, it's so much harder. You're not there in the room with your colleagues or with the judges. You don't get the same immediacy. I think it's a real skill. I think, unfortunately, notwithstanding the fact that we're recovering from the pandemic, this kind of submission is here to stay. I think in your practice, you will all find that you have to do this from time to time. Personally, I'd say I don't like it. I'd much rather be in the room. But I think you're doing a great job at really a very high level. This is a difficult skill, and I all thought you did fantastically. And particularly for prosecution counsel, technical problems can happen. It's how you deal with it, which is important. I thought you handled that really well. It's every counsel's nightmare, but you handled that brilliantly. So well done. In general, without talking about obviously the substance of the problem, because we're not allowed to do that, but I think the big challenge here is there are so many different issues that you could talk about. And so there is a bit of a temptation, particularly for the prosecution, because of course you have to satisfy all of the elements, whereas the defense can just sit back and pick some holes in what you say. But I think nonetheless, the challenge is to really choose those points which you think are the critical points for your argument, and try and give them a little bit more space and a bit more focus. And that's important both because it's easier for the judges to understand really where the heart of the case is, and also because it gives the judges a bit more chance to ask questions. And I know questions can be annoying as an advocate because you're like, well, I want to talk about these things and the judges are hung up on this and they pick me up on that. But it's also the moment when I think all of you were at your most persuasive. When you have a bit of dialogue, both between one another and between you and the bench, for me, that's when the submissions really come alive. And I thought you all did a great job of being responsive, but the more of that you can do, the better. There is, of course, a skill the other way sometimes in just getting your submissions into the transcript and not really giving the judges an opportunity to ask you a question. And that's a skill too. But on the whole, particularly with this kind of issue, I think you're looking for judicial engagement if it's there. The final thing I would say is, of course, I say pick your battles. Also, sometimes knowing when to stop is also an art. And sometimes you might have one argument which seems really good to you, but actually if you stand back in hindsight and think, I didn't really need to make that argument. You know, it's a good argument, it's a nice argument, I like it, but actually my case is fine without it. And sometimes leaving one alone can also be very persuasive because it makes us think, well, okay, they're so confident in the 3 points they gave me. Actually, that last point, they don't really need it. You know, I've won already. So I think your performance was great. I would say, think about your strategy, think about the points you want to hit, and really make those your big points, because you've got the rest of it. You're all great. You can talk till the cows come home. You're very persuasive. You know the law, you know the facts. So think about what is going to persuade us. But anyway, thanks so much from me. Really well done. I really enjoyed all of it. Thank you very much.
Thank you very much, Judge Matthew and Judge Kazushige. And now to the final deliberation on the winning team and the best speakers. Our winning team for today was N03. And our first best speaker is Defense Counsel 1. And the second best speaker is Prosecutor Defense 3. The Prosecutor Counsel number 3. Thank you very much and congratulations to all of you.
Thank you so much for the feedback.
So I think
the ICC is now adjourned. And I will stop the live stream now. You can leave the meeting if you want to.